Good afternoon, everyone. I want to welcome everyone to this afternoon's meeting of the Senate Committee on Legislative Operations and Elections. Madam Secretary, we do have quorum. Please mark the majority leader and the minority leader present when they arrive. I want to just go over a couple of housekeeping matters. Please ask everyone to silence their electronic devices. During the hearing, if you wish to testify, please sign in at the table by the door and provide a business card to the committee secretary if you have one. For those joining online, please be sure to mute your microphone when you are not speaking to minimize any background noise. When testifying, please turn on the microphone, and if possible, we'd really like you to clearly state your name, spell your name, and if you're affiliated with any organization or represent any organization or groups, please let us know. Then turn the microphone off each time you're done speaking. If you are having handouts, we ask for 20 hard copies for members of the public that should be on the table here by the door. Electronic copies should have been submitted in PDF form to our committee manager 24 hours in advance of the committee meeting. They should be up on the NELA system for the public to look at. We do deal with a lot of bills that generate a lot of passions in this committee, and even so, we expect courtesy and respect in our interactions during the meeting, even though we may not agree with someone else's position. Committee members will be using their laptops to view handouts and other documents. Please do not view this as a sign of disrespect or inattention. It's part of our modern legislative process. As a reminder, we may take agenda items out of order. At the end of the bill hearings, we will take public comment at the end of the meeting. That will be limited to 2 minutes per speaker. With that, I'd like to start with Assembly Bill 13. We've got representatives from the Nevada Attorney General's office. I'll open that hearing, and thank you for joining us on such short notice. Good afternoon, Chief of Staff.
Thank you so much. Thank you so much, Chair Orenshaw, members of the Senate Legislative Operations Committee, for hearing Assembly Bill 13. I do have down south our Senior Deputy Attorney General in a Personnel Division, Michelle Alanis. So after I give testimony, we do have someone available to answer questions for you. The Nevada Whistleblower Protection Act, contained in NRS 281, provides for an administrative process to appeal reprisal or retaliatory action that was taken against a state employee because they disclosed information concerning improper governmental action. AB 13 proposes to amend the Nevada Whistleblower Protection Act because the Personnel Commission attempted to create a limitation period for filing a whistleblower appeal through the enactment of a regulation, and that was Nevada Administrative Code 281.3051A. However, the Nevada Supreme Court invalidated it on the grounds that the Personnel Commission was not authorized to adopt a jurisdictional rule through its rulemaking authority, and that was State of Nevada versus Bronder in 2020. Therefore, the issue of setting a time frame for filing an appeal has to be addressed by the legislature. AB 13 is necessary to clarify what the limitation period is for filing whistleblower actions to reduce litigation, to foster the preservation of relevant evidence, to ensure that an appeal is concluded at a time when evidence and witness testimony is fresh, and to promote diligent prosecution and to promote finality to disputes. Additionally, Assembly Bill 13 removes provisions of the Whistleblower Protection Act which are in direct conflict with disciplinary procedures set forth in NRS Chapter 281 and NRS Chapter 284, including taking away the authority of administrative hearing officers to order the termination of the individual employee who's accused of the retaliation. Under the current version of the Whistleblower Protection Act, administrative hearing officers have the authority to order that accused individual to be terminated from their employment. We are proposing to remove this language as it violates the employee's due process rights and conflicts with other procedures afforded to the employees under NRS 284 and NAC Chapter 284. I'll walk you through the bill real quick. One section bill, but does good things. In Section 1, you're going to see that in Section 1, Sub 1 is where we have repealed the original time frame of 10 days, and now we're proposing 60 days. We're proposing that 60 days as it aligns with local government, and so there will be consistency between state and local government in the time frame for the appeal. In line 29, so Section 1, Sub 2, you're going to see this is where we strike the language allowing for the hearing officer to allow for the termination of the employee. That is the conclusion of the changes we're making to this part of chapter, and we're happy to answer questions for you.
Thank you very much, Chief of Staff Benitez Thompson. Members, any questions regarding Assembly Bill 13, either for the Chief of Staff or the Chief Deputy Attorney General in Las Vegas? I'm not seeing any questions. Thank you very much for the presentation. With that, I'd like to go to anyone else in support of Assembly Bill 13, either here in Carson City or down at the Sawyer Building. Anyone who'd like to speak on the record in support? Okay, I'm not seeing anyone. I'd like to go to opposition. Anyone, oh, pardon me, actually support on the phone lines, broadcasting. Is there anyone on the phone lines in support of Assembly Bill 13 who wishes to be heard?
To testify in support of AB 13, press star 9 to take your place in the queue now. Chair, there are no callers wishing to testify in support at this time.
Thank you very much. And I'd like to now go to opposition to Assembly Bill 13. Let's start here in Carson City, down at the Sawyer Building. Not seeing anyone broadcasting, anyone on the phone lines who wishes to be heard opposed to Assembly Bill 13.
To testify in opposition of AB 13, press star 9 to take your place in the queue. Chair, there are no callers wishing to testify in opposition at this time.
Thank you. Anyone who is neutral and wants to be heard on Assembly Bill 13, here in Carson City, down in Las Vegas, the Sawyer Building. I'm not seeing anyone broadcasting on the phone lines. Anyone who is neutral to the measure who wants to be heard?
To testify neutral to AB 13, press star 9 to take your place in the queue. Chair, there are no callers wishing to testify neutral at this time.
Thank you very much. Chief of Staff, any closing comments? We appreciate you presenting the bill, especially on such short notice. Thank you very much for being here. With that, we will now close the hearing on Assembly Bill 13. And before I open the hearing on Assembly Joint Resolution 6, I just want like the presenters to be able to come up and make their presentation. Then I'll go to support testimony. I'd like to do 30 minutes of support testimony. Then I'll go to opposition testimony, 30 minutes. Then I'll go to neutral, 30 minutes. And if everyone hasn't had a chance to speak, I'll try to cycle back, make sure everyone gets an opportunity to speak. So with that, our presenter on Assembly Joint Resolution 6, if you'd like to come forward, we appreciate you being here also on short notice and presenting this measure.
Thank you, Mr. Chair, members of the committee. For the record, I'm Howard Watts. I have the pleasure of representing Assembly District 15 in Clark County, and it's my pleasure to present Assembly Joint Resolution number 6 for your consideration today. I am joined by Eileen Reevy with the National Popular Vote, who will assist me in presenting this bill. First, I'd like to provide a little bit of background, a high-level background on what the bill does, why I feel it's important, and then we'll turn it over to Ms. Reevy to provide some additional background and walk through the provisions of the resolution itself. So what AJR 6 would do is have Nevada join the National Popular Vote Interstate Compact. This is an ongoing effort among states to allocate their electoral votes collectively to the winner of the national popular vote in the contest for United States president. And I'll also just bring up, this is something that did come before the legislature previously in 2019. It ultimately wasn't successful. I was a co-sponsor of legislation working to enact this then, and I felt that it was important to bring it back for consideration by the legislature and ultimately by the voters of the state of Nevada. Here's why I think this is really important. So, as somebody who has done work directly in civic engagement, trying to get people in our community involved in our democratic process, I look back on the history and progress that this country has made in increasing democratic participation. Obviously, at one point in time, our United States senators were chosen by state legislatures. They weren't elected directly by the people. That was a change that we made. We've, of course, seen the expansion of voting rights to women, to people of color, and to youth between the ages of 18, 19, and 20, who originally did not enjoy the franchise. Additionally, in the election of the United States President itself, our Electoral College is enshrined in the Constitution. Nothing says that electors have to be picked by the voters. And at first, they weren't. They were selected by state legislatures. And states ultimately today retain the power to determine how electors are assigned. Currently, most states do that through a winner-take-all system in the elections in their state. Some allocate their electors differently through the winner of the vote in individual congressional districts. And ultimately, I feel that that results in certain voters' voices not being heard. There's a wide variety of those scenarios. If you are a Republican voter in a strong Democratic state, that state is always going to give its electoral votes to the Democratic candidate for president. And those Republican voters' voices, their votes really don't count in a presidential election. Same thing if you're a Democratic voter in a strong Republican state. And ultimately, even in our swing states, with close elections decided by sometimes thousands of votes, relatively small margins, whoever is the winner of that winner-take-all election, whoever was on the losing side of that, their votes essentially no longer count for determining who the president of the United States is. And when I think about it, at the end of the day, we are not electing the president of an individual state. We're electing the president for this entire nation. And I believe that every voter's voice should have the same weight in making that determination. And that is what AJR 6 seeks to do. If or when enough states join this compact that would equal a majority of the Electoral College, that's 270 Electoral College votes, this compact would go into place, and all of those states would allocate their electoral votes based on whichever candidate for president wins the popular vote across the entire country. While this is a constitutional amendment that is proposed, I think it's important to note a couple of things. One, again, I think it's important that because we're expanding voting rights in accordance with some of those other things, I should also mention that recall, referenda, and ballot initiatives were another expansion of people's voting rights and powers. So while this would go into the Constitution where some of those other provisions lie, if the state decided that they wanted to withdraw from the compact, they could do so through statute. So I just wanted to make sure that that's noted. And of course, in order for this to be enacted, it would have to be passed in 2 consecutive legislative sessions and then approved by a vote of the people. So that, at its core, is what the resolution seeks to do. It is why I've brought it forward. I know that there will be some questions that will come up, and I think Ms. Reevy may have some remarks to that, and otherwise I'll be glad to answer those as they come up from members of the committee. But at the end of the day, I think this is about ensuring every voter's voice has the same weight and is counted in determining who the president of the United States is going to be, and that is why I've brought this forward. So if it's all right with the chair, I'd like to turn it over to Ms. Reevy to provide some additional background, then we'll answer any questions that the committee may have.
Certainly. Thank you, Assemblyman.
Thank you.
Please state your name for the record and proceed.
Thank you. Eileen Reevy, spelled E-I-L-E-E-N, last name R-E-A-V-E-Y. So good afternoon to all of you. It's nice to see you. I really appreciate the opportunity to speak about this bill today because I do think this is going to be one of the most monumental election reforms that we see passed in our lifetime. As Assemblyman Watts shared, the National Popular Vote Bill will guarantee the U.S. presidency to the candidate who receives the most popular votes in all 50 states and D.C., applying the fundamental principle of one person, one vote to our presidential elections. It does this by awarding Nevada's electoral votes to the candidate who receives the most popular votes, and very importantly, most popular votes in all 50 states and DC, and very importantly, does not go into effect until we reach that 270 threshold. I'm going to start by going through the provisions of the bill. So Article 1, as an interstate compact, this is the same language in all states that it's considered in. So Article 1 is just the membership, recognizing that the 51 jurisdictions that currently have electoral votes, which, of course includes the District of Columbia, that any of them are able to join the interstate compact. Article 2, it is the right of the people in member states to vote for president and vice president. It is saying that if you are a part of this compact, you must have a popular vote election in your state, and that any state that has that is what will be tallied to the national popular vote. Article 3 is really the part of the compact that lays out the manner of appointing electors in member states. So this establishes the mechanics of a national popular election by prescribing the manner of appointing electors. So the first 3 clauses are really the main clauses for implementing this. And the remaining clauses deal with administrative matters, various contingencies, and technical issues. Specifically, when we are looking at this, important ones to note are that the 4th clause of Article 3 requires the timely issuance by each of the compact's member states of an official statement of the final determination of their presidential vote. This is something, of course, that is also currently provided by federal law. The 5th clause establishes that compacting states must treat as conclusive the results of other states. Compacting states are not able to say and make any interpretation about what any other state's final vote count is. What is put out by that state is what they must accept. And the 6th clause deals with the very unlikely event of a tie across the national popular vote, which would say that in Nevada, we would revert back to the current winner-take-all system, and in all member states, they would revert to their previous method of awarding electors. Article 4 is the additional provisions. Actually, excuse me, I skipped one. Also, importantly, the governing clause. So this bill, we must have 270 electoral votes by July 20th of a presidential election year for this bill to go into effect. And then there is a 6-month blackout period. So no state may have their membership joining or removing themselves from the compact during that 6-month period, which is really important to note that, there is no way for states to try and game the system that way. They are locked in one way or the other, which is good for all parties involved when they're running for the presidency. And very importantly, this withdrawal clause, it's a part of an interstate compact, and no state has ever in the history of our nation removed themselves from the compact without adhering to the terms of the compact. The additional provisions in Article 4 specify the time when the compact could initially take effect. Then the 3rd clause also looks at the process by which states notify each other of the fact that they are entering or leaving the compact. Article 5 is our, definitions, just making sure we are all on the same page, since, of course, across the country, a lot of states use different terms for things when it comes to their elections. And then finally, that the final article is that legislature may withdraw from this compact, as Assemblyman Watts shared. It does not have to go back to the voters for the state legislature to do that. Going through this bill, this truly is a nonpartisan reform. This is about making every American's vote equal in our presidential elections. Electing the person with the most votes does not inherently favor one political party or the other. If it did, it wouldn't be how we elect our governors, member of Congress, or all of you. As Assemblyman Watts said, winner-take-all is not in the U.S. Constitution. And in fact, at the Constitutional Convention, it wasn't debated. It's not in the Federalist Papers. What the Founding Fathers decided, and the framers of the Constitution, was to give the state legislature that power. They were seen as the closest body to the people. They could make the right decision for the people. And certainly hope that you will think that awarding electoral votes by national popular vote is in the best interest of Nevada, all Nevadans and all Americans. We do have, a number of folks who I think you're going to hear from who oppose this reform for a number of different reasons. And so I kind of want to address some of the most common objections that we hear, across the country, and also some things that I've seen, submitted into the online testimony already. In our day-to-day lives, most people don't have a reason to know the population totals of states, right? You can kind of just say some states are big, some states are small, but that's not something really any of us has on hand. So I think it's a natural reaction to say that, oh, big cities or big states are going to somehow control the election, that they're going to vote 100% of the way for one candidate and just have so many people that they get to decide. In reality, if we look at the 2020 census, 19% of Americans live in the 100 largest cities in this country. Rural America is 20% of our nation. Elections are very importantly won and lost in the 61% of those people that are in between, which is, of course, our suburbs, where voters are consistently evenly divided between Democrats and Republicans. And similarly, yes, we do have big states. California and New York do have a lot of people, but they have less people than all of rural America combined. They have 18% of the US population. And realistically, there's not a reason to worry about California dominating a national popular vote for president. If we look at the 2016 election, and in that election, a number of people in California voted for Donald Trump, of course, right? The largest amount of Republican voters in any state are in California. And if you put together a group of some South Central states, there's 14 states that Nate Cohen has deemed Appalachiafornia, that their composition is almost identical to that of California. Population-wise, the way that they broke for Donald Trump instead of for Hillary Clinton. So you can realistically not think that a candidate would ignore those 14 states in their election any more than you would think that they would ignore California. And when this bill was drafted back in the early 2000s, it was knowing that states might want to use alternative voting methods in the future. And the national popular vote is compatible with ranked choice voting. So any state that chooses to use ranked choice voting for the presidential election will simply report out the final round of votes as the total for that state. And when we're talking about, that adding up that national popular vote total, yes, as I said earlier, the chief election officials within all 51 jurisdictions of our country, they put out an official statement, a certificate of ascertainment that has to go to the Library of Congress, and they must be put out 6 days before the Electoral College meets. Within the compact, states are not able to say, oh, no, I'm going to use something else. They must treat as conclusive those numbers, and I personally do not think that we need some sort of federal task force to calculate a national popular vote. I think our secretaries of state and our governors are perfectly capable of adding up those 51 jurisdictions totals and determining the total. And there is also not, a long history of states producing and certifying inaccurate vote totals, as we sometimes hear when I'm talking about this around the country. One example that I come up against quite often is that New York left off 400,000+ voters in their official count in 2012. That did happen on the certificates of ascertainment. Hurricane Sandy displaced tens of thousands of people right before Election Day, and the Board of Elections decided not to spend millions of dollars to count all of those provisional ballots ahead of the deadline imposed by federal law. They were all counted eventually, but not by that particular deadline. Now, President Obama won New York by 1.9 million votes. There was no question that those 425,000 votes were going to change the outcome of the election. And the co-chair of the board at the time stated that if it had that potential to change the outcome, they would have spent the money to do it. They would have made it a priority to make sure that every single vote was counted by that federal deadline. And I think this actually highlights the fact that, unfortunately, in states using winner-take-all, when you have a state that is overwhelmingly Democratic or Republican, you cannot count certain states, 400,000 voters, and it doesn't really make a difference into the awarding of electoral votes. Similarly, no candidate gets millions of extra votes inaccurately in California in 2016, as I saw highlighted in some testimony online. California uses fusion voting or in presidential elections. It's not common that they do it, but it is allowed by state law. So yes, a candidate can appear on that certificate of ascertainment twice if they were the candidate for more than one political party. but that doesn't mean their votes are counted twice. If the votes for Donald Trump had been counted twice in that presidential election, he would have won the state of California and their 55 electoral votes. That is just simply not how it works. So they wouldn't be double counted under a national popular vote. And I understand, if you are a citizen, that is not something that you need to know. But I think that, if you are with an organization that you work on this issue a lot, I think knowing that, yes, California allows fusion voting in presidential elections is a good thing to know. Unfortunately, it is, we have a lot of folks that throw spaghetti against the wall of trying to oppose this and see what sticks. For the last 16 years, as we've been advocating for this, we stick to our principles of one person, one vote. Whoever gets the most votes wins. Every vote should be equal. And we have seen a rotation of ideas of people opposing it for various different reasons. I think it's because it's hard to really talk against one person, one vote, right? It's a pretty basic principle. It's how all of you are elected. So we see a lot of other things thrown out there, but we do always respond to them at National Popular Vote. We, in fact, actually have a textbook that's over 1,000 pages that addresses a lot of things that we've heard over the years. So just, in my closing here, with this bill, no voter is going to have their vote canceled out at the state level, as happens now, because their choice differed from a majority sentiment in their state. Every voter's vote will be added directly into the national count for the candidate of their choice. This retains the power of the states to control how a president is elected, and it is in your power to work with other states to repair the Electoral College and improve our electoral system. This bill has been introduced in all 50 states. It's supported by over 3,500 state legislators and dozens of national, state, and local groups across the country. 15 states and DC have already signed on. They have 195 electoral votes out of our necessary 270. I am happy to report that we have passed at this point in this session both chambers of the Minnesota Legislature with bipartisan support. Our bill is moving in the Michigan Legislature, and actually, in about 35 minutes, a hearing is going to start in the Alaska Senate. It'll be our second hearing in front of the Alaska Senate considering this bill, and we are very appreciative that they are considering it. The way that we elect the president is broken, and I appreciate all of you for considering this tangible constitutional solution that is already 72% of the way towards enactment. This is the one reform that puts voters first, recognizing that every vote cast for president should be equal. Thank you.
Thank you. And with that, we're glad to take any questions from the committee.
Thank you very much for the presentation. I appreciate it. Members, are there any questions? Senator Krasner.
Thank you, Chair, and thank you for your presentation. I had a couple questions, I think, for Ms. Reevy. Did I say that right? A few things. There's this old book, and it's the second time I brought it out today. It's called the United States Constitution. You probably read it. I see, in Article 2, Section 2, that our founding fathers have actually enumerated how each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the whole number of senators and representatives to which the state may be entitled in Congress. So they've called out how these electors should be chosen. But what it seems like your bill is trying to do is circumvent the United States Constitution and basically amend the United States Constitution. And so I would direct you to Article 5 of the United States Constitution, where our founding fathers clearly called out 4 different ways that the United States Constitution can be amended. And it just seems like you can call it a compact, you can call it whatever you want, but it seems like you're trying to circumvent the United States Constitution and Article 5 and the method by which states and Congress, the 4 ways to amend the Constitution. And I know you said, some people throw spaghetti to try to find a way to oppose this, but some people also feel like you're circumventing the United States Constitution and Article 5 by doing this. So I don't know. What are your thoughts on that?
Thank you for that question, Senator Krasner. Howard Watts for the record. I'll start by answering it because it's my resolution that I brought forward. So I appreciate those concerns. I disagree with them. Here's why. In the first section that you mentioned of the Constitution, it explicitly gives the power to state legislatures to determine how their electors are allocated. So that is a power given directly to the states. As I've mentioned, states currently use different methodologies to do that. And previously, in some of the first elections that we had, they were not determined with any input from the voters whatsoever. Then we moved to kind of the system that we have today, which is in most states, decision by winner take all in their states, but in some states is allocated based on winners in congressional districts. So this is a power that individual states have. What I'm proposing and what this proposes is, one, to guarantee that the voters will always have a voice in this process moving forward in determining who the president is, and two, that we have the ability to, again, an individual state could choose to allocate its electoral votes based on the winner of the national popular vote right now. What we're trying to do is make sure that we do that in a concerted effort with other states to ensure that the actual outcome is that the winner, the U.S. president is a contest among the entire country, so we want the person who gets the most votes across the country to win. That is, since it is within the power of an individual state to determine, it's also within the power of states to come together. I know that one of the other things that's been, so you mentioned this bypassing either I feel it doesn't bypass the Electoral College because, again, states determine who their electors are, and that is still done here. Additionally, you mentioned this bypassing some sort of constitutional amendment process. It leaves the Electoral College in place. This is simply a method that states would choose to come together and allocate their electors based on a different methodology. And so if you want to argue that that somehow circumvents the Electoral College, you can, but again, at the end of the day, the determination of electors and how they're allocated is a power that's delegated specifically to the states. One other thing that I will mention that is not exactly under what you've described, but is another concern I've heard, is that somehow this is unconstitutional because it is a compact that is not going to be ratified by Congress. Case law has determined that there are essentially kind of two sets of compacts. There are compacts where the issues involved supersede the powers and authorities of an individual state. One example I can think of in Nevada is the Colorado River Compact, right? Governing the management of that river that flows through multiple different states, and some of the aspects of how that works supersede the jurisdiction of any individual state. So that had to be entered in among all the participating states and then ratified by Congress. There's also another set of compacts that are within the powers delegated to the states. We have so many licensure compacts, for example. One that Nevada's a part of is the Interstate Medical Licensure Compact. That compact was not ratified by Congress. And the reason is things like the licensure of occupations are powers that have been delegated to the states within their jurisdiction. And so states choosing to band together and apply a uniform methodology across those states for items that are within their authority can be enacted without requiring congressional approval. I hope that provides some clarification.
Thank you, Assemblyman. Any follow-up, Senator Krasner?
Yes, thank you, Chair. So the Colorado River Compact has a few states that make it up. It's not all 50 states, number one. And number two, what you are doing here is seeking to change the way that the President of the United States is elected. And you both stated that in your testimony. And that is something that our founding fathers did address in the United States Constitution. And you did say that you want to amend the state of Nevada Constitution to make sure it's enshrined in stone of how it will be done. And how what will be done, choose the President of the United States that again is here. Our founding fathers decided how that will be done. They called that out. They did give leniency to the states and the state legislatures, but they also made it clear that there are only 4 ways to amend the United States Constitution, and those are called out in Article 5.
Thank you. Howard Watts for the record. Again, those are 2 separate sections of the United States Constitution. The Founding Fathers envisioned one thing and one thing alone in creating the Electoral College, and that is that the states decide how they allocate their electors. Under this, Nevada will still have its 6 electors. We're going to choose to allocate those 6 electors to the winner of the national popular vote in concert with other states that would choose to do the same. Again, ultimately, we've seen a move towards this. Originally, again, we've seen a move towards increasing the power of individual voters to participate in the democratic process. And at the end of the day, I respect the fact that that people have landed on kind of the current methodology. But again, states could adopt different methodologies tomorrow individually. It's totally constitutional, and they could enter into some other arrangement because that is within their state authority to do so. I think that, again, essentially the district that the candidates for president are running in, it's not a congressional district, it's not a state, it's the United States of America, and I believe that each voter's weight across the country should be held equally in making that determination.
Thank you very much. And as someone wants, if AJR 6 were to pass this legislative session, it would need to be considered again in 2025, and then it would go to a vote of the people?
Howard Watts for the record. Thank you, Chair. That is correct. So that is our method for initiating state constitutional amendments via the legislature. So it would have to be passed this session. It would have to be passed again in 2025 in identical form. And then it would go to the ballot in 2026 for the people to decide if this is the direction that they want to go. As I had noted earlier in our testimony, this explicitly does provide that if for some reason we decide we do not want to remain part of the compact, we can withdraw from the compact via statute, so it does not require a subsequent constitutional amendment if for any reason we decided that we wanted to withdraw. The earliest that this could take effect from kind of the perspective of Nevada joining would be for the 2028 presidential election, assuming that we hit that threshold by July 20th of 2020 across all the United States.
Thank you, Assemblyman. Members, any additional questions? Okay, Senator Krasner.
Just one, thank you, Chair. One quick thing. You just said if we, you're proposing a state of Nevada constitutional amendment that has to go through the Nevada legislature twice and then a vote of the people, and then it will be enshrined in the Nevada Constitution. And then you said that if we want to get out of the compact, all we simply have to do is withdraw, but that's not true, because if it's enshrined in the Nevada Constitution, we will have to amend the Nevada Constitution again to take it out, which will require 2 legislators to consecutively vote yes on it in identical form and go to another vote of the people. Isn't that correct?
Thank you for that question, Senator Krasner. Howard Watts for the record. If I'll direct your attention to page 6 of the proposed resolution. This is in the last element, so proposed to be section 14B, subsection 2. The state of Nevada may withdraw from the National Popular Vote Compact by statute and may rejoin by subsequent statute, subject to the provisions of subsection 4 of section 14A of this article. So again, our power derives from the Constitution, so while we be amending the Constitution and essentially saying we want to join this, we are explicitly reserving the power to the state legislature to choose if we would want to withdraw from the compact at some point in the future or to rejoin. So an additional constitutional amendment would not be necessary if we were to enact this, because we are specifically reserving the power back to the legislature to decide how it would like to proceed moving forward. Again, ultimately, one of the things that I want to do, this is about the power of individual voters and how they feel the United States president should be elected. This language allows us to put that to a vote of the people to decide what they want to do, while still reserving the legislature's fundamental power to ultimately decide how we wish to allocate our electors move in the future.
Thank you for pointing that out.
I-
Senator Krasner for a follow-up, and then.
Thank you very much, Chair. And actually, I'd like to direct my question to legal, because if we are amending the Nevada Constitution, and there is a process to amend the Constitution, as you said, go before the legislature twice and then a vote of the people, to take this out would take an additional amendment, I believe, regardless of the fact that you have put this language in here. And I'm just wondering if legal could please give us an opinion on that. Thank you.
And certainly, Mr. Fernley, I'm fine with that. But if you'd like to get back to us, that's fine as well, too. Mr. Fernley.
Thank you. If this resolution were to be approved by the legislature twice and approved by the voters, that provision that's being referenced would reserve to the legislature the power to withdraw from the compact by statute. So because that power of the legislature is in the Constitution, you wouldn't need a further constitutional amendment to get out of the compact if the legislature exercised its authority under that provision to withdraw from the compact by statute.
Thank you, Mr. Fernley. Does that answer your question, Senator Krasner?
Almost. Would you need a further amendment to the Nevada Constitution to remove the language from the Nevada Constitution, however?
You know, I don't know exactly. You might, but the language would have no effect because the legislature would have withdrawn from the compact by statute. So to get the language out, yeah, you might, but the language would be of no effect because the legislature has withdrawn.
And then if I can follow up, Mr. Fernley, then assuming that this passes, this legislature, AGR 6, passes in same form in 2025, the voters approve it at the 2026 election, and for some reason the subsequent Nevada legislature decides that they want us to withdraw from the compact, that can be done by legislative action. It would not require a subsequent constitutional amendment to withdraw from the compact.
Yes, that's correct. It wouldn't require a subsequent constitutional amendment to withdraw from the compact. The language would be in the Constitution, but it would have no effect. The legislature would have withdrawn from the compact by statute.
Thank you. Thank you for clarifying that. Members, any additional questions? Okay, I'm not seeing any. Thank you for the presentation. I'd now like to go to support for Assembly Joint Resolution 6, and I'd like to start with 30 minutes of support. Then I'm going to go to opposition, then I'm going to go to neutral, and I want everyone to get a chance to speak. So I'd like to go to support. Sir, your microphone's not on. If you turn on your microphone, please state your name for the
Sorry
record and
about
proceed.
that. No worries. My name is Raymond Haynes. I am a national spokesman for the National Popular Vote Interstate Compact. Just give you a little background on me. I was a member of the California Legislature for 14 years. During that time, I was the Senate Republican whip. I was also the Assembly Republican, Assistant Republican leader for 3 years. In those days, Kevin McCarthy was the Republican leader. I was the chairman of the Senate Constitutional Amendments Committee for 4 years. I was the 2000 national chair of the American Legislative Exchange Council. I am a conservative, and I am in support of the National Popular Vote Interstate Compact. If you have any questions about my conservative credentials, talk to your colleague Jeff Stone, who actually was the mayor of Temecula when I was the senator in his district. So we have a long history together. I thought I'd talk a little bit about my evolution on this. If you get up on YouTube and search National Popular Vote, you will find the speech I gave against the compact when it was in front of the California Legislature in 2006. Still, in my opinion, the best argument I've ever heard against it. But I was wrong on all my facts. Once I got informed, I came to the conclusion that this is what was best for America and best for the individual voters in each of the individual states. I want to emphasize a couple of really important things. This does not, the National Popular Vote Interstate Compact does not eliminate the Electoral College. In fact, I think it strengthens and preserves it. The Electoral College is, in my opinion, a very important institution and should be preserved. This keeps that flexibility in that and preserves that Electoral College. And here's a big issue. The problem in the current Electoral College is not the structure. The Article 2, Section 1 says, each state shall appoint in such manner as the legislature thereof may direct a number of electors. The Supreme Court has held in what I call a true Scalia-style original intent, in such manner as the legislature thereof may direct means exactly in such manner. By state law, you choose how your presidential electors are determined. You get into the Federalist Papers. There are two big Federalist Papers addressing the Electoral College, Federalist number 68, Federalist number 45. 68 by Hamilton. What Hamilton thought was going to happen in the Electoral College is what the legislatures were going to appoint the electors. They were all going to get together and debate who should be president on the appointed day. Poof, the white smoke would come out of the top of the state capitol, and boom, you'd have a president. That worked exactly the way Hamilton thought it was going to work, as long as everybody agreed that George Washington should be president. The moment you had the fight between Jefferson and Adams, you had a fight over how the legislatures chose the president. And interestingly enough, in 1800, Virginia changed its law on how it appointed electors for the specific purpose of electing Thomas Jefferson, the Virginian, president. That was actually the first real incarnation of the winner-take-all law. And winner-take-all that's now in effect in 48 of the 50 states actually did not really become in effect in a majority of the states until 1836. So literally a generation past the founders. The problem in our current system is the winner-take-all law, not the Electoral College. And in the last 20 years, what we have seen is a growing instability and a lack of voter faith in the electoral process because of the winner-take-all laws. In 2000, 2004, 2016, and 2020, what you have seen, because in 2004, 500 votes would have changed, a change of less than 500 votes would have changed who became president. In 2004, 60,000 votes in Ohio would have changed the outcome. In 2016, a change of 40,000 votes in 3 states, Pennsylvania, Michigan, and Wisconsin, would have changed the outcome. And in 2020, of course, a change in 3 states of 23,000 votes in Georgia, Arizona, and Wisconsin would have changed the outcome of the presidential election. In 2000, 04, and in 16, it was the Democrats who complained about the voting process. In 2020, it was the Republicans. What we have seen the winner-take-all law do is undermine the faith of the American people in the process of electing the President of the United States. And if we as I shouldn't say we, I'm no longer state legislators, but if state legislators have one thing they ought to do, it ought to be preserving the faith of the American people in the electoral system. And I believe the National Popular Vote Interstate Compact actually does that. I'll make 2 other points real quickly. Number one, the question is, what do the voters want? What do the voters think is more important? A lot of the opposition you will hear say, well, this makes Nevada irrelevant. Well, I think, quite frankly, what you'll see in 2024 right now is the pundits, political pundits, are saying there's only going to be 6 states that are going to matter in who becomes the President of the United States. Those states are Arizona, Georgia, Wisconsin, Michigan, North Carolina. You'll note that Nevada is not in that 6-state number. That means, quite frankly, 90% of the American. Point of order. Did I do something?
Oh, excuse me. We have someone speaking up here.
Is this a timed testimony?
Right now, I'm going to 30 minutes for support, then I'll go 30 minutes to opposition.
I'll be done in a
So please,
minute.
gentlemen speaking.
Yeah, thank you. Okay, I'll be done in a minute. If the concern is I'm talking too long, I apologize. I'm a politician, I get paid by the word. But the bottom line is, we should have a real concern where 90% of the American public has no real input into who becomes president of the United States. Another objection that has come is concerns over how the votes are going to be counted. The fact is, the compact itself has a process. You rely on what the chief election official in each of the states says is the final vote. The process of how they get to that final vote, quite frankly, is irrelevant to the compact. We rely on the states to choose it. In the end, voters care that their vote counts. They really care that their vote matters. They don't really care what their state does, to be real blunt. Nobody has an election party on Electoral College Day and say, gee whiz, I'm glad my state voted for the losing candidate, and so I'm going to have a victory party for my state. They care who wins the election. And in the end, we choose over 500,000 elected offices in this country by the popular vote. There's only one that we don't, and this is it. And I think the winner-take-all law has undermined people's confidence in that process. And we should do things to strengthen that. Thank you.
Thank you. Please state your name for the record and proceed.
Thank you. Good afternoon, Chairman Orange, Shaw, and committee members. For the record, my name is Emily Prasad Zamora, PERSAUD-ZAMORA. I'm the Executive Director of Silver State Voices that leads the Let Nevadans Vote Coalition, and today we're in strong support of AJR 6. The concept of one person, one vote is the cornerstone of our democracy, reflecting the fundamental notion that each person's voice should carry equal weight in shaping our society. Upholding political equality means a consistent effort to remove barriers to voting and to promote inclusivity, diversity, and representation at all levels of government. Nevada has made great strides over the past few years to modernize our election systems and ensure all voters have the ability to cast their ballots. Enacting the National Popular Vote Compact would strengthen Nevada's leadership in safe, secure, and equitable elections. We're hopeful that this will move forward, and we look forward to voters having a say in their democracy. We thank Assemblyman Watts for bringing this bill forward. We urge your support. Thank you.
Thank you for your testimony. Please state your name for the record and proceed.
Hello, my name is Jennifer Willett, and I am here in my personal capacity to support AJR 6. Nevada has taken significant strides to ensure accessible elections through policies such as universal mail-in ballots and same-day registration. As a result, Nevada has become a national leader in promoting democratic ideals. By joining the National Popular Vote Interstate Compact, Nevada will continue to champion democratic values and ensure that every vote is counted equally. No voter should be disadvantaged based on where they live, and every American should have an equal say in who becomes our president. AJR 6 represents a crucial step forward towards ensuring that every vote is counted equally and that the will of the people is accurately reflected in our electoral process. Thank you.
Thank you. Good afternoon. Please state your name for the record and proceed.
Good afternoon, Chair Orenshaw and members of the committee. My name is Annette Magnus, and I am the Executive Director of Battleborn Progress. We stand in support of AJR 6 because we support the principle that every person's vote should count equally in every presidential election, and we thank Assemblyman Watts for spearheading this important bill and for his leadership this session, because we believe the biggest form of disenfranchisement is the perception that one person's vote doesn't matter. Letting Nevada voters decide this critical issue Let Nevada voters decide this critical issue, and you should all let us decide how Nevadans want to deal with this matter. I would also like to say the last time I testified on a bill like this, it was sponsored by Assemblyman Tyrone Thompson, and I hope we can honor his legacy with the passage of this measure. Please support AJR 6.
Thank you very much. Anyone else in support here in Carson City who wants to be heard? Okay, not seeing anyone. Down at the Story Building, anyone who's in support, please state your name for the record and proceed.
Good afternoon, Chair and members of the committee. For the record, my name is Aria Flores, ARIAFLORES, and I'm here on behalf of Chispa, Nevada, and with the Let Nevadans Vote Coalition, and we are in support of AJR 6. Nevada is amongst the states leading in making elections more secure and accessible for all of our voters. In this exciting time, we also have a chance to do our voters right by updating our institutions when it comes to presidential elections. The Electoral College caters to a select few states, and under the Electoral College, the notion of one person, one vote is abandoned. Although Nevada serves as a battleground state under the Electoral College, we understand that this process is not a just one. By adopting national popular vote, we ensure that every voter is counted fairly and that the people's voices across our country are treated equally. This will make our state more responsive and representative of the many opinions of our citizens on who should be the President of the United States. I encourage you to support AJR 6. Thank you for your time.
Thank you for your testimony. Anyone else in support down in Las Vegas? All right, broadcasting, can we go to the phone lines? Anyone who is in support of Assembly Joint Resolution 6?
To testify in support of AJR 6, press *6 or *9 to take your place in the queue.
Thank you, Chair and members of the committee. My name is Eric Jang, ERICJENG. I am the Director of Outreach for Asian Community Development Council, as well as the Acting Executive Director for One API in Nevada, advocating on behalf of the growing Asian, Native Hawaiian, Pacific Islander population here in our great state. Here in strong support for AJR 6, want to say ditto and thank Assemblywoman Watts for sponsoring this joint resolution. Thank you.
Good afternoon, Chair Orange-Hall and members of the committee. My name is Toby Tyler, a volunteer member of the Sierra Club's Legislative Committee. On behalf of the Sierra Club, the world's largest environmental volunteer organization, and our more than 30,000 members and supporters statewide, I'm speaking in support of Resolution AJR 6. AJR 6 proposes an amendment to the Nevada Constitution that provides for joining the NPVIC, which is the National Popular Vote Interstate Compact. This means that Nevada will choose its electors for president based on which presidential candidate wins the national popular vote. AJR 6 allows one person, one vote to count toward electing our president, in contrast to our unique in the world electoral system, which renders most votes in the country inconsequential and allows 5 to 6 states to determine the outcome of the presidential election. Frequently in the past several election cycles, winner presidential election has come down to a very few votes in the few swing states. This is not fair and distorts the outcome of our elections to favor a small number of voters in those swing states. Since it is exceedingly difficult to eliminate the Electoral College system to fix these inequities, the best option is to join the NPVIC, which will have the effect of electing the presidential candidate with the most popular votes. For these reasons, we urge your support of this joint resolution. Thank you.
Thank you. Broadcasting.
Hello, and thank you, Chair Orenthal and Committee. My name is Dayla Gibson, DAELA-GIBSON, and I'm representing Planned Parenthood Votes Nevada. We are in support of this bill and ditto other statements in support. Thank you.
Yes, Sharon Shaw, members of the committee, Doug Goodman, D-O-U-G-G.
And I'm sorry, it's having a little trouble hearing you, caller. Could you please speak louder? Please say your name for the record and proceed.
Yes, Chair Arnshaw, Doug Goodman, D-O-U-G-G-O-O-D-M-A-N. I'm founder, executive director, Nevadans for Election Reform. During the 2019 session, the legislature passed AB 186. Chair Arnshaw, Majority Leader Canizero, and then Assemblyman, now Senator Daley, voted yay. Senator Sievers-Gansert and then Assemblywoman, now Senator Krasner, voted nay. Governor Sisolak vetoed the bill. There is a difference between AB 186 and AJR 6. AB 186 was a statute. the legislature was deciding if Nevada was to join the National Popular Vote Interstate Compact, and legislators were voting based on what they believed was best for Nevada. HJR 6 asked should Nevada voters have the opportunity in 2026 to decide if they want the state to join the NPVIC and award us electoral votes in accordance with the compact and in accordance with the U.S. Constitution. Your vote on HJR 6 does not mean you support or oppose Nevada joining the NPVIC, as your vote on AB 186 did. Vote on HJR 6 simply means you value the opinion of your constituents, that you support the concept that as their representatives in the legislature, you believe they have a role in determining how Nevada and the nation elect our president and vice president, and that you have faith and trust in their judgment. I'm certain you do have that faith and trust, and will vote to let Nevada voters decide what is best for Nevada and the country. Very much appreciate the time.
If you have just joined us and would like to testify in support of AJR 6, press star 9 to take your place in the queue. Chair, there are no more calls wishing to testify in support at this time.
Thank you. I'd like to now go to opposition to Assembly Joint Resolution 6, and I'd like to start with a 30-minute block of time for opposition. I'd like to start here in Carson City. With the witnesses, please take seats. Whoever would like to begin, state your name for the record and proceed. And then I'd like to kind of cycle back and forth, Carson City, Las Vegas. Please state your name for the record and proceed.
Our states, oh, there we go. I am with Save Our States Action.
And I'm sorry, please state your name for the record again. And could I trouble you to spell their name too, for the record?
Sure. Sean Parnell, SeanParnell, with Save Our States Action, an organization, national organization focused on defending the Electoral College and opposing the National Popular Vote Compact. I've spent about 10 years on this issue, and I've done a fair amount of what I think of as technical analysis of the compact. And basically, the conclusion I've come to is that it is defective. It is very badly written. I think that when Ms. Reevy was referring to people throwing spaghetti against the wall, she might have been referring to my work, because I'm the one who has spent a fair amount of time looking at things like how does the compact interact with ranked choice voting? What does the California 2016 Certificate of Ascertainment mean for this compact? Basically, all of these issues and others get to the core defect of this compact, which is that there is not actually an official national popular vote count. What you have instead is the chief election official of each member state responsible for independently going out, obtaining vote totals from other states, both member states and non-member states, and then aggregating these vote totals to come up with a national popular vote total. The problem is that because there are 50 states plus DC that all have their own election codes, they all do things a little bit differently. In some cases, the things that other states do can cause real problems for the compact, things that will cause confusion, controversy, chaos, and crisis, because it will be impossible to come at a obviously accurate and conclusive vote total. This might not matter if you have a 10 million vote national margin. But if you have a close national margin, and by my count, 4 of the last 16 have been close, you're going to have a crisis of legitimacy where it simply cannot be conclusively determined who won the national popular vote. And I'll go ahead and list a couple of the problems that are going to arise. New York is really bad at counting all of the votes on time. Ms. Reevy referred to 2012, where they left about 425,000 votes off of their certificate of ascertainment, and explained correctly that that number was so high because of Hurricane Sandy. However, in 2008, they were missing about 87,000 votes. In 2016, they were missing 102,000 votes, and they were missing about 29,000 votes in 2020. Simply put, New York is not very good at counting all of the votes on time. However, under the compact, your Secretary of State is going to be required to accept vote totals that are inaccurate and incomplete. That seems like it's going to be a problem, especially in a close national election. The problem with ranked choice voting is that the compact anticipates that every state is going to produce a single vote total for every candidate. However, under ranked choice voting, there are at least two vote totals. There's an initial vote total, and then there's a final vote total after the ranked choice process runs itself through. And while it is going to be the case that the certificate of ascertainment for Maine and probably Alaska, those are the two states that are going to use ranked choice voting in 2024, there will be a single vote total, probably the final. Actually, in Maine, it will be the final vote total. However, the compact does not require that the certificate of ascertainment is the document from which vote totals must be obtained. There are, in fact, several official statements, that's the term in the compact, there are several official statements that other states are going to produce as part of their election process. I'm going to read a quote from John Koza, founder of National Popular Vote, a memo he sent to the 2014 Connecticut legislature. Quote, "The National Popular Vote Compact does not depend on any particular piece of paper." Skip ahead a little bit. Quote, "The final determination of a state's presidential vote does not have to come in the form of the certificate of ascertainment. It could just as well be evidenced by, say, the official minutes of the State Board of Canvassers or any other official document from the state containing the vote count." Now, what you have in the packet of materials that I sent you are official statements from both Maine and Alaska from their 2022 elections, reporting on their ranked choice voting elections for U.S. Senate in Alaska, Congressional District 2 in Maine. And what you will see on that official statement are three sets of numbers, vote totals in Alaska, two different vote totals in Maine. It will be at the discretion of your Secretary of State which document they choose to treat as the official statement, and then if they choose one of these statements, they are obviously going to be forced to choose which vote total do they want to incorporate into their national vote count. And because those vote counts can differ by tens or even hundreds of thousands of votes, again, in a close election, you could literally be handing the power to choose the winner based on which set of vote totals your Secretary of State decides to accept from Maine or Alaska or any other state. There's another problem with ranked choice voting, which is if it is in fact the final vote total that is going to be used, if that's the one that's chosen, then if you have a third party or independent candidate who just finishes in second place in any state using ranked choice voting, and that's happened more than 70 times in this country's history, dating back to 1892. Ross Perot was the last one to do it in 1992. I think personally that Evan McMullen probably would have finished ahead of Hillary Clinton in Utah in 2016 if that state had ranked choice voting. What winds up happening is that third place candidate, the Democrat or the Republican, winds up with having hundreds of thousands, potentially millions of votes erased from the national vote total. Because of course, as part of the ranking process, when you get down to the last two candidates, the vote total for that third place candidate is 0. If that affects the outcome, I think you're going to have a lot of people very unhappy with that outcome. There's also an issue that if there is no official statement available to obtain vote totals from, your Secretary of State is empowered to estimate vote totals for that state. This was actually testified to in North Dakota in 2021 in a hearing on a bill that would have basically hidden the vote totals. The idea was that they wanted to thwart the compact. It's not a very good idea, but the point is that if for some reason there's no official statement from a state, your Secretary of State gets to estimate, and the methodologies that were described by those two NPV lobbyists in North Dakota would have been off by thousands, tens of thousands, even hundreds of thousands from what the real vote was. Again, a close national election, this is going to be a big problem. There was some discussion of what happened in California in 2016. California actually does have fusion voting for president. However, that is not what happened in 2016. In the packet that I included for you, you will see a sample ballot for San Luis Obispo County in California. And what you will see is that they put one line for Donald Trump and Michael Pence, and then they listed that they were the candidates of both the American Independent Party and, of course, the Republican Party candidate. But there were two separate slates of presidential electors. Also in your packet is the 2016 California Certificate of Ascertainment. When the California Secretary of State went to count up all of the ballots, because he had included both parties on a single line, even though there were two separate slates of electors, what they wound up doing was treating every single vote for Trump and reporting every single vote for Trump as two votes, one for the Republican slate of electors, one for the American Independent Party slate of electors. You can look at the certificate of ascertainment. You can see that the names for the electors are different. When New York does fusion voting, it's the same slate of electors, the Working Party's family, the Democrats, and any other party that wants to endorse the Democrat. They have a single slate of electors. That works in New York. In California, because they had two separate slates of electors, they had to report on their certificate of ascertainment 4.4 million votes for Donald Trump on the Republican Party line and 4.4 million on the American Independent Party line. Under the terms of the compact, because your Secretary of State is supposed to simply go down the official statement and pull all of the numbers off, they would have been required to add in those extra 4.4 million votes, which seems pretty outrageous. I promise I'm about to wrap up here, but one other thing I will simply point out is that the compact promises, at least in its rhetoric, to count every vote from all 50 states plus D.C. However, that actually is not the case. It only pledges, according to the text of the compact and the book that they have published, Every Vote Equal, they will only count votes from states that run their elections the way National Popular Vote defines a statewide popular election. And if you look, what you'll find is that past historical practices by many states, things that people can do today in terms of how they cast their votes, and the proposed reforms would not be included in the National Popular Vote count. I'll go ahead and wrap up there.
Yes, I
Yeah.
apologize
No,
if
I
you
get
could I appreciate your comments. If you could bring them to a close, just because the bell rung, we have to run down to the Senate floor for an address by Congresswoman Titus, so we'll go into a recess. Then we will come back to continue the hearing. But please take your time and wrap up your
All right.
comments. I don't mean to stop you.
No, I
in your
understand
tracks.
completely. I'll take 1 minute and just wrap up here.
Go ahead.
National Popular Vote imposes a broken vote counting process that in a close national election is going to cause a crisis. The crisis is not my term, by the way. It is the term of the law professor, one of the law professors who initially developed the concept of National Popular Vote, Professor Vikram Amar. He has described this compact as having, quote, dangerous gaps, end quote, that will lead to, quote, electoral crisis. If you want to get rid of the Electoral College, do that through a constitutional amendment where a lot of these problems I've talked about simply get cleared up and are not a problem. If you want to deal with winner take all, deal with winner take all. You can do that this year. You don't have to do this compact that frankly may never go into effect or will go into effect years from now. If you want to deal with winner take all, just deal with winner take all.
Thank you very much, Mr. Parnell. Thanks for your testimony. If I could indulge everyone just to hang tight. We heard the bell to go down to the floor, so we will be in recess and we will resume the hearing as soon as we hear from Congresswoman Titus. Thanks, everybody. We are in recess.
Well done. Thank you.
If anyone's hungry, there should be some food in 2125, so please help yourself. Yeah, I did order some food for this late night. I banged up my knee, but that could be that. Well, that can't tell you. Thanks, everyone, for your patience. We are back to order. We do have a quorum. We were, I think, 10 minutes into opposition testimony. So whoever would like to proceed, we're going to stay here in Carson City, then we'll go down to Las Vegas, and then we'll keep cycling back and forth. So we'll go here in Carson City, and then we'll go down to Las Vegas.
Thank you, Mr. Chairman. My name is Janine Hansen. I'm the state chairman of the Independent American Party. I was very interested in the conversation that we had previously. The reason, this is the fourth time we've had the national popular vote in this building. 3 times, of course, it was defeated. And the reason we have a constitutional amendment this time is because in 2019, Governor Sisolak vetoed national popular vote. And of course, they anticipate that Governor Lombardo would veto national popular vote. So they had to go to an alternative method to try to get this passed, and that's a constitutional amendment. But it's just amazing to me to hear things like every vote matters, what do voters want, one person, one vote, every vote counts, and then to look on page 6 on line 3 where it talks about how they will vote and put this into the Nevada Constitution, that all those votes count, everybody should vote, and put it into the Nevada Constitution, and then just obliterate what the people did and have the legislature change their mind and do whatever they want. It's just astonishing to have such an incredible precedent set by overturning the process for a constitutional amendment in Nevada. Nowhere else in the Constitution is this allowed. Nowhere else can the legislature overturn a vote of the people. But that's precisely what this bill, this constitutional amendment, allows to happen. And it's just astonishing, especially with their claims of every vote matters, because obviously with this section of the bill, it doesn't matter, because the legislature can overturn the vote of the people. National popular vote will also hurt Democrats as well as Republicans. The National Vote Compact has no minimum percentage for a candidate to be declared national popular vote winner. This means that in a 3-way race, that a candidate could win with as little as 35% of the vote. That could have happened with Ross Perot. It did happen in 1912 with Teddy Roosevelt. Wilson was the beneficiary of that. He received 41%, Roosevelt 27%, and Taft 23%. And of course, with President Abraham Lincoln, he was elected in a 4-way race and got only 39% of the vote. And we recognize that with no national mandate, what happened? We devolved into civil war. This is a very important issue, and it should not be done with a constitutional amendment which violates the precedent in the state of Nevada. Thank you, Mr. Chairman.
Thank you. Whoever would like to go next, please state your name for the record and proceed.
Thank you, Mr. Chairman. Sean Meehan, founder of Guard the Constitution Project. This testimony is extremely important to me. Last Friday afternoon, my favorite uncle, passed away. In our conversation we had the Wednesday before, he reminded me that he enjoys that I share the Constitution as I understand it, and hopefully others can understand the constitutional originalism in time. I will attempt to not throw any spaghetti against the wall. I regularly consult in my work with constitutional scholars and attorneys. And as was stated by Ms. Hansen, previous attempts are being moved away from to avoid a gubernatorial veto, and I think that's unfortunate. The compact clause is important here, as Thomas Jipping, a legal scholar at the Heritage Institute, wrote in an article that I can get to you online. He talked about that some states are strengthened and some states are weakened in the process. That is one of the criteria in a Supreme Court decision that triggers the compact clause applying. The founders envisioned only one thing in creating the Electoral College, which was said by the sponsor earlier. I'd like to ask the sponsor to read Federalist 68 and the debates of the 1787 convention, because I literally don't understand what that is to push back on it. It was a compromise between the strength of the people and the strength of the states. The states elect the president. There's no such thing as one person, one vote in the Electoral College. It's one state, one vote. Also, and I've talked to counsel about this, a very polite gentleman, we respectfully disagree, but I appreciate that he listened to me. Hawk v. Smith, the Supreme Court case, specifically defines the term legislatures, and I'm going to read a quote. The term legislatures, as used here and elsewhere in the Constitution, means a deliberative, representative bodies that make the law for the people of the respective states. The Constitution makes no provision for action upon such proposals by the people directly. Because we're amending our state constitution, as you ladies and gentlemen know, it requires a vote of the people. That violates Article 2, Section 1. You, ladies and gentlemen, your contemporaries, decide how we assign electors with no assistance from the people. I also point out a recent article that was in the Nevada Globe that hits the nail on the head. If this and SB 133 pass, you are setting up a horrific train wreck if Nevada doesn't vote for president with the national popular vote, but we have to force our electors to vote for them anyway. You are forcing the electors to commit a felony, as both of those laws are written right now. For 40 years, the League of Women Voters tried a constitutional amendment. I think that's an admission that that's what's required to accomplish this. Over 10,000 amendments have been attempted in the history of the Constitution. 700 of them attempted to amend the Electoral College. All of them have failed. And it's an important point to highlight that because 3 U.S.C. was amended recently earlier this year with the Electoral Count Act in the wake of 2020, specifically it clarified that when states decide when they're going to vote in a certain safe harbor window, that may not be changed. So I don't want you, ladies and gentlemen, to have the impression from the sponsor that if we don't like the way this is going and the totaling is a problem, we pull back and go back to what we did. When the people of Nevada vote and the votes are being tabulated, we have to stick with the Electoral College because of what we did to 3 USC in Congress. Thank you very much, Mr. Chairman, for the time.
Thanks for your testimony. Please state your name for the record and proceed. And then as soon as you're done, I'd like to go down to the Sawyer Building. I know folks have been down there a while, and then we'll come back up once we've heard from the folks down at Sawyer Building.
Thank you, Chairman and committee. My name is Lynn Chapman, and I'm representing National Eagle Forum. Why would we want to take Nevada's voice away in the presidential elections? That is what the national popular vote does. We should want to have the voices of all Americans heard. A popular restraint is every vote matters, but that is not what national popular vote would achieve. In fact, it is just the opposite. According to Andrew Morgan, MBA from George Washington University and a master's from National Defense University, quote, if the president is elected based on a plurality, then the minority would not have a chance of having their candidate elected. Only the concerns and interests of more heavily populated areas, such as the East and West Coast cities, would be represented. Interests of the minority in less populated areas would naturally be set aside and of little interest to future presidential candidates. Worse, the executive would be beholden and accountable solely to the majority. He further stated, quote, minority voter interests will no longer matter at the national level. Only the whims of the majority will. And the result will be precisely why Socrates opposed a democratic form of government. Once a majority is established, it finds a way to remain permanent, and the majority class will become oppressive to the minority class. There will be no means to overturn the majority, no matter how skewed the majority's view may be, unquote. This is a very dangerous idea to try to put into our state constitution. Please vote no. Thank you.
Thank you. And for everyone here in Carson City, if I could ask for your patience, we're going to go down to the Sawyer Building. Thanks for your patience down there. If you please state your name for the record and proceed.
Good afternoon. I'm Susan Proffitt, VP of Nevada Republican Club. Governor Sisolak vetoed the popular vote bill because it would relegate our state to the back of the bus during a presidential campaign. Assemblyman Watts stated this ensures every voter voice would be heard, but it appears he fails to understand the dangers usurping the U.S. Constitution also hides within the rhetoric. The most glaring contradiction to today's pro-testimony I see is that Nevada is such a small state and we only have 4 electoral votes. So the popular vote process will dilute our vote, and president candidates may choose to skip Nevada altogether. Assemblyman said that we will choose 6 delegates, but delegating our vote to someone you choose isn't allowing my voice to be heard. We only have 4 electoral votes, and small states with smaller populations like Nevada will be discarded. Both Democrats and Republican candidates will ignore the state. Choosing to make a constitutional amendment appears to be the far, far left attempt to bypass Governor Lombardo, so Joe cannot veto it. When I checked, I discovered the only states who have passed it are heavily Democrat states run by Democrat governors. I believe America needs 2 healthy parties, so the extremes on both sides are not able to take us too far in either direction. With that in mind, I urge you to scrap this constitutional amendment, because even Democrat Governor Sisolak refused to allow to destroy our state. This is by a bipartisan request. You scrap this bill. And if he were really concerned about my vote counting, then I don't think you all would have ignored my pleas for help regarding the fraud I and our observers witnessed on a daily basis inside the Clark County Register of Voters. Thank you very much for your time.
Thanks for your testimony. Please state your name for the record and proceed.
Brittany Sheehan, Sheehan. It's been said that former Governor Sisolak did veto this, and I do believe it's a way to get around the veto. And as Senator Krasner and others pointed out, there's a very bizarre provision that then throws the power back to the legislature. So I think Nevadans will be very inconfident if we're flip-flopping every 2 years on the way that we're going to run these elections. And I think you're going to get a legal challenge, and it's going to be open to the interpretation of the Nevada State Supreme Court. I think that's very problematic. And I do think, even though I'm a Republican, I can say that Senator Harry Reid did a good job of making Nevada matter. And I don't think we want to go back on that. I think if you're a Republican or a Democrat, you want the attention in our state, you want to be first in the West in the presidential primaries, you want to have the advertising dollars and the campaign dollars, and you want Nevada to matter overall. And I think we're at risk of losing that. And I think you're telling Nevadans that their votes don't matter. And there's some people in this body that kind of mock that and call people who aren't confident in our systems conspiracy theorists. But I think that it's very sad if we have Americans lose their belief in democracy. And someone asked, what do the voters want? Well, we just had an election. We elected Governor Joe Lombardo, and in his platform was election integrity, security, and transparency. He has brought those packages and items to this body, and the people did vote for that. That's what they have voted for. So we need to focus on making sure that Nevadans are confident in their democracy and not whittling that away from them by every 2 years voting a different way or putting this into the state Supreme Court where we don't even know what's up from down. And I would just submit to you those ideas. I don't think those are hyper-partisan ideas. I think those are pro-Nevada ideas. And we heard from a lot of people today who weren't Nevadans. We heard from a former California legislator who gave you his big conservative record and said we could ask Senator Stone about it. But I asked Senator Stone his position on this, and he wasn't in support either. And so I submit that. Thank you.
Thanks for your testimony. Good evening, sir. Please state your name for the record and proceed.
John Colaw, Colaw. One of these things Sean kind of touched on, but you could literally have candidate A win the state of Nevada and give all the electoral votes to candidate B, who didn't win. Also, I'm wondering if, there's a procedure in the 12th Amendment to the U.S. Constitution how to handle ties in the Electoral College. Apparently, we don't need that anymore. That's why they want 270. So we take that away from them. And honestly, we still don't have the kind of control on our voter rolls to be mailing everybody ballots. The DMV, bless their heart, tends to do weird things like register people as living in a box in a UPS store. We've got actual real problems that are addressable, we need to address, this isn't the time or the place. Anyway, thank you for your time.
Thanks for your testimony. Good evening. Please state your name for the record and proceed.
Yeah, my name is Al Rojas. I live in Assembly District 12, Senate District 21. I am opposed to this bill for several reasons. One of the major reasons, well, there's many of them, but one thing that people are overlooking is that you as people in the legislature realize that the presidential elections pull more people to come to vote every 4 years. So less people are going to most likely participate in the electoral process. So it's not going to really be a representation of people will eventually not even want to be involved maybe as much as they are now for a regular election, and numbers may go down. So the presidential election does seem to bring people out. We all know that generally speaking, you get an extra 10 or 15, probably to 20% people participating in a electoral election year. So that's going to be an issue. And then also, I think every state should really be able to say how they feel. So every state should speak up for itself who they want as a candidate, as a presidential candidate. You know, your voice is your vote. And why would you want another state to speak for you? You know, you got to speak for yourself. We want to speak for ourselves as Nevadans, whoever runs for office. So, and it's going to take interest from people coming to our state as well. So I'm totally opposed to this. And just take into consideration, a lot less people are probably going to participate in the decision-making process. Thank you very much.
Thank you for your testimony, Mr. Rojas. Thanks everyone for their patience. Anyone else at the Sawyer Building who wants to speak in opposition who didn't get a chance to? I'll come back up to Carson City. Thank you for your patience. Whoever would like to begin, please state your name for the record and proceed.
Good afternoon, Chair and committee members. My name is Caroline Smith. I'm the Nevada Federation Republican Women's State President. Dear committee members, the Nevada Federation of Republican Women has 20 clubs statewide and more than 1,600 members. The Nevada Federation of Republican Women passed a resolution on February 22nd, 2019, to oppose the National Popular Vote Interstate Compact. Please vote no on AJR 6. It amends the Nevada Constitution to adopt the National Popular Vote Compact, and it essentially abolishes the Electoral College. The Electoral College balances the interests of high populations and low population states. Without the Electoral College, the 4 most popular states would decide the fate of the country, and thus the remaining 46 states, which we are one, would have little control over their state interests. Again, I'm asking you to vote no on AJR 6. I'd like to read our resolutions. I'll do it as quickly as possible. The NVFRW resolution, we oppose the National Popular Vote Interstate Compact on any legislation that would effectively abolish the Electoral College. Whereas the Electoral College is an important part of the founders' design of our federal form of government in that it gives each state a significant voice in the election of the president and vice president of the United States, and prevents a few states with the highest population density and covering a relatively small geographic area from deciding the election of the president and vice president. Whereas the founding fathers choose the Electoral College over direct election in order to balance the interests of high population and low population states, and without the Electoral College, the four most populous states, California, New York, Texas, and Florida, would decide the fate of the country, and thus remaining the 46 states would have little control over their state's interests. Whereas once the National Popular Vote Interstate Compact is adopted by a state, all the state's electoral votes would be awarded to the winner of the National Popular Vote, regardless of how the votes of that state had voted, thus effectively disfranchising the voters of the state. Now there it be resolved that the Nevada Federation of Republican Women opposes the National Popular Vote Interstate Compact or any legislation that effectively abolishes the Electoral College. Thank you for your time, and again, I request please vote no on AJR 6. Thank you.
Thanks for your testimony. And we are just at 30 minutes of opposition testimony, so I'd like the two witnesses here to be able to state their name, speak, then I'd like to go to neutral, cycle back through. Everyone will get a chance to speak, but we could go with these two witnesses, then we'll go to neutral, see if there's anyone else in support, we'll come back to opposition. So please state your name for the record and proceed.
Absolutely. Thank you, Mr. Chair. Melissa Clement, Nevada Right to Life, MELISSACLEMENT, and I'm registering our opposition to AJR 6. Nevada is a small state with a number of unique issues. No other state has the amount of federally owned lands that we do. Mining, gaming, and water are issues fairly unique and important to our state. And most illustrative, as Congresswoman Titus mentioned today, since the 1980s, Nevada has fought the federal government and other states in the Union who wanted to dump their nuclear waste in our state. We have fought them back successfully. As a state, we hold our own on a national basis. Why is that? It comes down to our 6 electoral votes. 6 votes out of 270 doesn't seem like a lot, but each presidential candidate must put together a path to 270, and that requires them to campaign with geographic diversity. That is why it's important for Nevada. Those votes bring candidates here. And then I just have a multimedia presentation. Bernie Sanders in 2019 was actually in Carson City and Elko. Pete Buttigieg, he was in, Reno. Vice President Kamala Harris was here in these halls, and I remember seeing her. Here she is with our beautiful state of Nevada flag. Amy Klobuchar was here during the last 2019 legislative session. In fact, she was here to campaign for national popular vote. Why did she do that? Because she never wanted to go back to Elko again. Sorry. If the election becomes, please don't tell Mr. Gert I said that. If the election becomes just about popular vote, those votes can easily be harvested from the major cities, making the urban issues of the highest population cities the issues that candidates will hear about and will respond to. This is not a partisan matter. This is a Nevada matter. A vote for AJR 6 gives away significant power that we have at a national level. As representatives of Nevada, I can't think of a good reason to vote for it. For the benefit of the state of Nevada, I ask you to vote against AJR 6. Thank you very much.
Thank you, and I'm sure the Vice President liked Elko. Please state your name for the record and proceed, sir.
Good evening, committee and chair. Jim DeGraffenried, I'm Nevada's Republican National Committee man, and I'm in opposition to AJR 6 on behalf of the Nevada Republican Party. We're opposed to AJR 6 as we have been in the multiple sessions where this has come up because we don't believe that it makes good sense for Nevada to work so hard to become first in the West in the primary election and then relegate ourselves to irrelevance in the general election. Nor should Nevadans surrender our voice to bigger states. Nevada's votes for president should not be decided by voters in other states. As a point of fact, this compact would require ratification by Congress, as it does affect all 50 states. Compacting states would be trampling on the rights of non-compacting states in this scheme by denying them their voice. It is the equivalent of, say, Clark and Washoe counties ganging up on the rural counties without their permission. Because this is a nonpartisan issue, I have the rare opportunity to say that Governor Sisolak stated the issue extremely well when he vetoed this legislation in 2019. I want to put some key parts of his veto message on record. The governor said that while reasonable people may disagree as to whether the national popular vote should dictate the ultimate winners of presidential and vice presidential electoral contests, this is a notion that does not reflect the delicately balanced system of government that issued from the larger debate at the Constitutional Convention of 1787. The MPV agreement, which when enacted would require a signatory small states electoral delegates to vote in support of candidates for president and vice president who win the national popular vote, could leave a sparsely populated western state like Nevada with a greatly diminished voice at the outcome of a national electoral contest. End of quote. This is not a partisan issue. Nevada is a battleground state and it receives significant attention from candidates, both in the primary and in the general election, and from all parties. Our First in the West contest creates significant opportunities for all Nevadans. Democrats and Republicans have pointed this out numerous times over the years. They recognized how important the silver state status is to all Nevadans, regardless of party affiliation. Please protect Nevada's voice and oppose AJR 6. Thank you.
Thank you very much. I'd like to now go to neutral testimony. Anyone who's neutral on AGR 6 and wants to be heard here in Carson City. I don't see anyone down at the Sawyer Building. Broadcasting, anyone on the phone lines who's neutral, who wants to be heard.
To testify neutral to AGR 6, press star 9 to take your place in the queue.
Hi, before starting to testify, I just am a little bit confused. I thought we were testifying in opposition, and I didn't hear you guys asking the people on the phone for opposition.
Ma'am, we're in neutral now, but we will get back to opposition in just a little bit. So right now we're in neutral testimony.
Okay, I will stay on the queue. And
Thank you.
Caller, press star 6 to unmute yourself, please. You're unmuted.
Yes, I'm with the previous caller. Again, you didn't give the chance to state opposition to the phone people.
Yes, sir. We'll go back to opposition.
That there will be an appropriate time to do that.
So if you hang on,
Thank you very much.
We'll go back to opposition. Please don't disconnect, or please call back if you get disconnected.
Caller, press star 6 to unmute yourself, please. One moment, Chair.
Waiting for opposition. Sorry.
Chair, there are no callers wishing to testify neutral at this time.
Thank you. And I'd like to just cycle back. Was there anyone else in support that did not get a chance to speak? Don't see anyone coming forward. Broadcasting, is there anyone waiting for support testimony? If not, we will go back to opposition.
To testify in support of AJR 6, press star 9 to take your place in the queue.
Waiting for opposition. Sorry.
Thanks for your patience.
Chair, there are no callers wishing to testify in support at this time.
Thank you. Now, broadcasting, if we can go to opposition, I know the folks on the phone lines have been very patient, and then after opposition, we'll come back up to Carson City. So anyone in Carson City, if you'd like, you can take the seats up here if you'd like to be heard, but we'll go to the phone lines first, then we'll come to everybody's been so patient here.
Testify in
hi.
opposition of AJ. Sorry.
Hi, my name is Katrin Ivanov, aka Mrs. Fixit, and I live in Assembly District 42, Senate District 9. I am in very, very big opposition of this. This is going to change what the Constitution was meant to be. I don't think anybody that is living today is smarter than the people that made the Constitution and put the Constitution and the Bill of Rights. Because of these two documents, we were able to survive for a very long time. Grant you, for many years, people have been trying to erode and been eroding the Constitution little by little, and that's why we are in the mess we are right now. If we go back to following the Constitution, things are going to be much, much better in this country. If the federal government stops taking more rights than is given by the Constitution, if the elected officials stop taking more rights than they're given by the Constitution and stop acting like they're kings, but they start representing us, then things are going to be much, much better. Because I don't see how giving away the rights of Nevadans is in the benefit of Nevadans. That just don't make sense. Even 12-year-olds can see that. So please, I beg you, start representing your constituents and vote no on this appalling bill. It's not a bill, it's whatever, ASJ's, whatever. I'm just really upset. I'm so sorry. Please vote no on this. Thank you so much. And I know you're working hard. You have, 900 bills for 3 weeks. So it's not an easy job, but I hope that you listen to us and vote no. Thank you.
Tyrus In 2012, I believe it's the Atlantic, after the presidential election, they talked about how it's great that we should keep the Electoral College. Then in 2016, they talked about how Electoral College is messed up and it should be overturned. Now, the obvious reason is because those media outlets didn't get the outcome that they wanted. Same people who are talking about packing the courts were the same people several years ago talked about it keeping it at 9 justices. All this is about getting the outcomes that you don't want, or getting the outcomes that favor whatever you're trying to take us to. If you go back to these media articles and how they flip-flop in every position, you can see the whole grand theme of it all. Other than that, I will ditto many of the comments made by the previous speakers. Thanks.
Hello, my name is Michael Ryan, Michael-Ryan. I'm a longtime resident of Nevada and a Marine Corps veteran. Please vote no on AJR 6. It will make Nevada a meaningless flyover state in presidential elections and do away with all of Nevada's work to become significant in the presidential election. California, Texas, New York, and Florida will decide who the president is. National popular vote circumvents the Electoral College in our U.S. Constitution. Please vote no on AJR 6. Thank you.
Am I being heard?
Yes, we can hear
Am
you.
I being heard?
Yes, we can hear you. Please state your name for the record and proceed.
My name is Ellen Gifford. The Presidential Electors Clause is part of the United States Constitution. AJR 6 refers to that clause and a quote that says it was framed to ensure that the appointment and mode of appointment of electors belong exclusively to the states. These references emphasize the importance of each state having its own voice in the election of president and vice president. Oddly, this is in direct contrast to what the national popular vote does. Nevada became a state in 1864 and has participated in every U.S. presidential election since then. Nevada has its individual and unique environment, its individual and unique commerce, its unique population of citizens, makes its own presidential choice, and has its own voice. The votes of Nevada citizens should not be mingled with or canceled by the votes of California, Texas, or any other state. But this is what the national popular vote seeks to do. It also seeks to cause our presidential electors to violate Nevada election laws. NRS 298065 states that in order to be a presidential elector, a person must sign a pledge that says they agree to vote only for the nominees who receive the highest number of votes in their state. In violation of this law, AJR 6 requires a state's presidential elector to mark their presidential elector ballot for the national popular vote winner, regardless of who won in their own state. Nevada votes are cast by the citizens in Nevada, processed in Nevada, and counted in Nevada. They are the votes of Nevada citizens and should represent Nevada's election results, not the election results of another state. I oppose AJR 6. Thank you.
Hello?
Yes, please state your name for the record and proceed.
Members of the Senate committee, my name is Jill Douglas. That's JILLDOUGLASS. I am president of the Battle-Born Republican Women of Southern Nevada. We oppose AJR 6 because it is a bad bill that makes Nevada voters insignificant. The way we elect president is not broken. 88% of those voicing opinion on Nellis are in opposition to this bill. I would say please listen to this popular vote and support your voters. Your constituents overwhelmingly oppose this bill. Governor Sisolak did state the issue very well when he vetoed this legislation in 2019. He knew this would greatly diminish the voice of Nevada voters, forcing Nevada to agree with a national popular vote, ignoring or diminishing the will of the people. Our founding fathers realized the dangers of a national popular vote as it could lead to a tyranny of the majority. Accordingly, they created the Electoral College system. This system helps give states with smaller populations, such as Nevada, an equal representation. This is not a partisan issue. Do not take away the voice of Nevada. Do not take away the voice of Nevada. To suggest that a state should disregard its own voters and instead follow the will of the voters in some other state is the exact opposite of what our framers envisioned. I hope the Nevada Legislature is committed to the presidential election process that is fair, inclusive, and stable, one that preserves the best of our history of a republic democracy. The national popular vote puts all of these things at risk. Please vote no on AJR 6. Thank you.
Good afternoon, Oscar Williams for the record, OSCAR, WILLIAMS. I'm opposed to this bill. It proposes a compact of states, but we are, of course, the United States. It creates division by its very nature. Are we going to now be opposed to other states that are not in the compact, or is this going to be some issue that we have to contend with as sort of outliers? And of course, all the previous commenters have made great comments regarding how it will affect our sort of flyover nature. Let's face it, in the presidential race, there's no reason that Nevada would have any clout or effect on what's happening the idea that we would have some compact is just is really an affront to our Constitution. And there's no reason to support this bill. It's been opposed by a Democrat governor, and I hope we all come to our senses and realize that this is just nonsense and we're wasting our time here today. Thank you for your time.
If you have just joined us and would like to testify in opposition of AJR 6, press star 9 to take your place in the queue.
Hello, good evening. My name is Irina Cardenas, and I strongly oppose this bill. I think it's just so incredibly wrong to keep these attempts to strip Nevadans, citizens of Nevada, of their voice, of their constitutional voice. This is a clear violation of our constitutional right, and I strongly oppose it. I ditto all the valid points. I really hope that you act in good faith and represent the majority voices and opinions in your communities. And there is a lot of people across the board that are rejecting this bill. So please don't ignore Nevadans. We strongly oppose this bill. Thank you.
Yes, I'd just like to ask a question. Why do we need
Excuse me, sir.
to circumvent the governor?
Pardon me, sir. Please, if you could state your name for the record. And please state and remind everybody to spell their name too.
I don't feel comfortable in doing that. I don't feel we have a free country anymore. I don't like what's going on. And I would like to give my free speech right now. Is that okay? Because we're doing this without the governor's signature. Why do we need to go to those extremes? Maybe because it won't pass. But we're trying to pass a bill here that is all about the popular vote, about people voting. And yet we can't even do a norm, a democratic norm, to get something done. I'm just very dismayed about all this. Mr. Watts, you have some other bills before this legislature where you're not listening to constituents as well.
And sir, I don't mean to interrupt you, and I appreciate you being involved.
We're just very
we do need your name for the record,
sir. And you guys are not listening to anybody.
Sir, thank you for your testimony, but we do need your name for the record. Broadcasting, is there anyone else on the phone lines?
Yes, Chair, one moment.
Good afternoon. Can you hear me?
Yes, please state your name for the record and proceed.
Okay, my name is Eddie Facey, last name F-A-C-E-Y, and I was the Republican nominee for State Assembly in District 42 in 2022. Public confidence in elections is already low. Shortly after the 2020 election, CNN reported that 48% of Americans think that it is at least somewhat likely that election officials will overturn the results of a U.S. election because their party did not win. This lack of confidence is bipartisan, although for different reasons. Some believe that certain states make it too difficult to vote. Others believe that other states make it too easy to cheat. But when the aggregated mistrust in election officials is 48%, that is a number that's too significant to ignore. When elections are conducted at a state level, those who are mistrustful can do things to observe the conduct of the election and can redress grievances in a court of law. Under this legislation, stories of election misconduct taking place thousands of miles away could have more impact on Nevada's presidential vote than entire Nevada counties or even the entire electorate of Nevada. We frequently hear terms like fake news and fact checks, and we understand there's a tug of war over the legitimacy of reported news stories and their authenticity. Regardless, each and every story that someone considers fake news has another person considering it authentic truth. The likelihood that many of these disputed and unverifiable stories would impact our state's choice for the national leader does not enhance public confidence in elections. and even beyond fake news are the controversial decisions of election officials. When we hear stories of butterfly ballots, hanging chads, polling places closing early or opening late because of weather, power failures, or whatever, we understand that those results only affect the state where the events take place. Under this legislation, it would not only make those events more impactful, but give motivated partisan actors across the country an increased incentive to confuse and obfuscate in order to obtain a preferred partisan result. I urge your opposition on AJR 6. Thank you.
Am I being heard?
Yes, please state your name for the record and
Am
proceed.
I being heard?
Yes, please state your name for the record and
Craig
proceed.
Ullery. Craig Ullery, CraigUllery, Boulder City. My opinion is this legislation should be called the Why Bother to Vote legislation because it basically gives Nevada's electoral votes to the national popular vote. So a lot of people will be feel disenfranchised, which seems to be counter to the whole purpose of this. Our founders considered the national popular vote and rejected it because it would lack the checks and balances to protect minority rights and it would limit corruption. So this bill just seems to do the opposite of that. And I actually am astounded that the Nevada legislature would spend the time with all the issues that this state has to deal with on this sort of legislation. I oppose AJR 6.
Chair, there are no more callers wishing to testify at this time.
Thank you. I'd like to come back to Carson City. Thank you for your patience. Whoever would like to begin, please state your name for the record and proceed.
Good evening, everyone. My name is Joy Trushinsky, Trushenski. Please vote no on AJR 6 to place the national popular vote into the Nevada Constitution. It will effectively make Nevada no longer important in the presidential elections and do away with all of Nevada's work to become significant as a swing state. The Electoral College was set up to protect small populated states from the larger populated states to give the people in the smaller populated states a voice. All states should count in the majority or in the major decision to elect a president of the United States. The national popular vote circumvents the voices of the people and would destroy our state as a swing state. I did not agree with much that Governor Sisolak supported, but I sure did agree with him on this. Please vote no on AJR 6. Thank you very much.
Thank you for your testimony. Thank you for your patience. It's been a late night. Good evening. Whoever would like to begin.
Good evening. Bob Russo for the record. I oppose AJR 6 to the National Popular Vote Compact. I just want to mention that at about 4:30 this afternoon, I checked Nellis, and there was overwhelming opposition to this resolution. I think it was somewhere around 88%, give or take a few percentage points. I'll mention a few reasons why I oppose it. First, this compact would dissolve the Electoral College as we know it. A state's electoral votes, regardless of the vote of the people in individual states, would go to the winner of the popular vote. This would essentially eliminate the voice of smaller states such as Nevada in presidential elections while placing the destiny of our country in the hands of the most populated states. And has been mentioned already, the focus of the presidential campaigns would be on the larger states, California, New York, Florida, and so forth. We'd be a flyover state, quite insignificant. Another reason is, as Janine Hansen mentioned, a president could be elected with less than 35% of the vote if there's a third-party candidate in the election. This isn't good. This isn't good. Next, to my knowledge, no authority exists for determining the accuracy of the national popular vote for president. There could be disagreements between the states regarding who the winner is, while no national authority is in place to settle such disputes. I also believe that the institution of the National Popular Vote Compact would directly violate the Compact Clause of the U.S. Constitution. It gives votes to the winner of the popular vote without a constitutional amendment abolishing the Electoral College or consent from college. The Compact Clause prohibits states from entering into, quote, any agreement or compact with another state or with a foreign government without the consent of Congress. This is from Article 1, Section 10 of the U.S. Constitution. The National Popular Vote Compact is not the answer. The bottom line is that it undermines our representative republic that our founders clearly established, and I believe could eventually lead to a direct democracy, which James Madison describes unfavorably in Federalist Paper number 10. The Electoral College has worked well since the birth of our nation in providing a peaceful transfer of power, which is so unique in the world, a peaceful transfer of power. Why change something that has represented all Americans and has worked so well in the past? Again, this amendment or compact would essentially void Nevada voters. So I urge you to please protect the votes of Nevadans and the Electoral College by voting no on AJR 6. Thank you very much.
Thank you, Mr. Russo, for your testimony. Whoever would like to begin, please say your name for the record and proceed.
Thank you in advance for your time. My name is Celine, C-E-L-I-N-E, last name Cinq, C-I-N-Q. I only represent myself. I'm one of the worker bees, if you will. I don't participate in this type of sessions very often, but I felt compelled to come tonight to express my concern over this proposition. I support everything else that everybody opposing this has stated already, namely that it has not been accepted in 2019, so why are we revisiting this again? And unlike some of the people here, I don't have a whole bunch of legislature or laws or anything like that to quote because I'm not that familiar with it. However, I was trying to do a crash course during the recess that we had on the laws, and one of the things that popped up was that the government basically created the districts to afford the minorities to have a voice in the voting process. And I'm thinking to myself, well, if we do this whole popular vote, are the minorities going to be negatively affected? So that is something that we should consider, in my opinion. The other thing, too, that I'm concerned about is that if we have multiple states that get into this compact for the national vote, then it could potentially change the whole process for elections in the United States, where we come to have the national vote for everybody in the state if there's sufficient states that adopt this particular method. So I oppose this particular AJR 6, and should you decide to vote for it, I would strongly be appreciative if we would strike the paragraph 4, second paragraph, where any member state may withdraw from the compact except blah, 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 to where it would have to be submitted again to the popular vote if we want to withdraw, because as it was mentioned before, the population would be feeling disenfranchised even more if they give their vote to be part of the compact, but then we decide not to be part of the compact and so on and so forth. So I oppose this AJR 6. Thank you.
Thank you so much for your testimony. Thanks for your patience. Good evening, sir. Please state your name for the record and proceed.
My name's Jerome Fritz, Jerome Fritz, and I'm just an average Nevada voter. And AJR 6 disenfranchises me by taking away my vote, because I'm not voting for the popular person all the time. I'm not always a party line voter, and I vote for a person for merit a lot of times. If my person does not win, I don't want to be I don't want the only option to be to vote for the popular person. So you're forcing me to vote for somebody that I don't want to. I oppose it because I want my vote to count. Forcing me to vote a popular candidate takes away my right and my vote. I'm offended that they think I'm a party line voter or want me to vote that way, and I'm just a piece of sheep or cattle that just like goes with the herd, whatever. And then a founding father quote comes to my mind, Ben Franklin: "What we have here is a republic if you can keep it." And that's all I have to say.
Thanks for your testimony. Thanks for your patience. Good evening, sir. Please state your name for the record and proceed.
Weissberger. I'm opposed to this because, let's be honest, the proponents say it's a nonpartisan issue or bipartisan. I disagree. I think it's strictly partisan. I think the founding fathers put the Electoral College in there for a check and balance, which is a central theme of our government: checks and balances. The check against the popular hysterical vote of the population. It was an issue back then, and it's even more of an issue now, I feel, with corporate media, the corporate broadcast media being able to flame the fires of passion amongst the voting populace. I think it's a road to tyranny, electing a demagogue, basically. And also, I feel that this argument that was made by the proponents that it's unfair that the state's electoral votes would go for the winner, all for the winner of that state. Well, that's just like an election. You have a winner and a loser in each state, in each office. You have a winner and a loser, and it's the same. It can be the same thing for a state. Just not we're going to give 80%, or we're going to give a percentage to the guy or the candidate who won this percentage of the vote in this state, and the other percentage to the loser, to the next runner-up in the state. That's just not right. A popular vote on that basis. It's a matter of the state voting, the electoral college voting, for how that state voted, not just for each candidate in that state. So I feel that I beseech you to vote against this. Thank you.
Thanks for your testimony. Thanks for staying so late. Good evening. Please state your name for the record and proceed.
Good evening. My name is Teresa DeGraffenreid, DeGraffenreid. So sorry. The Electoral College exists because the framers of the Constitution believed that each state should matter in selecting the president. To suggest that a state should disregard its own voters and insist on following the will of voters in some other state is the exact opposite of what the framers intended. Properly amending the Constitution requires a supermajority of 2/3 of Congress or a state to first propose an amendment, and then full 3/4 of the state must ratify any amendments. Even in the NPV, compact is ultimately found to be technically constitutional. It remains a constitutional trick to neuter the Electoral College that can be forced on the nation by a minority of the states. This is fundamentally unfair and offensive to the amendment process specified in the Constitution. Under this compact, campaigns will naturally concentrate their efforts on large states and metropolitan areas because it's more efficient. A candidate can reach a population much larger than the entire state of Nevada and any of the American's largest states, and do so more easily. Supporters of NPV says that every vote will count, but under NPV, candidates don't need every vote. They don't even need a majority, only a plurality, and it's much easier for them to collect those votes in large urban areas. We often hear the argument that the national popular vote would correct the so-called failure of the Electoral College, which occurs when the winner of the popular vote does not win the electoral vote. However, it is important to note that this is not a failure. Under the constitutional system, candidates are not trying to win the popular vote. It is actually kind of an accidental when they do, at least in a close race. No football game has ever been decided on how many touchdowns the winning team scored, because football players aren't trying to score touchdowns, they're trying to get the most points. Whether from touchdowns or field goals, I think everyone on both sides of this issue today can agree that candidates will campaign differently. If the goal is to win the popular vote, there simply is no way to know who would have won the popular vote in any past elections, because no candidate will ever try to do so. On a personal note, I want to say that my family has been in this country since 1652, and we as a family has fought in the Revolutionary War, fought in the all the wars of this country, and I personally do not want to see that. I see this go through. I believe that the Constitution and the Nevada Constitution is just fine, and we need to just, go with the electoral votes and how it was originally set up. Thank you.
Thanks for your testimony. Thanks for staying so late to participate. Good evening. Please state your name for the record and proceed.
Barbara Jones for the record. And I just want to join in with the others in my opposition to the National Popular Vote, SJR 6, especially on constitutional issues. And the presenter said that people want to believe in their elections, and this bill, a national popular vote, doesn't restore the trust in our elections. So just urge you, please vote against it. Thank you for your time.
Thank you very much. Thanks for your testimony. Thanks for staying so late. Is there anyone else who wants to be heard either here in Carson City, either opposed, in support, neutral? I don't see anyone at the Sawyer Building. Broadcasting, is there anyone else on the phone lines that we might have missed?
To testify neutral, press *9 to take your place in the queue.
Hello, this is Pauline Lee, spelled Pauline, Lee, L-E-E. On behalf of Keystone Corporation, we are opposing AJR 6, which attempts to include the National Popular Vote Compact into our state constitution. Why are we revisiting this issue? This has already been discussed, reviewed, and researched. In 2019, the legislature passed the National Popular Vote Compact. This was passed by the democratically controlled legislature. Wisely, Governor Sisolak vetoed the National Popular Vote bill because, in his own words, the bill, quote, could diminish the role of smaller states like Nevada in national electoral contests and force Nevada's electors to side with whoever wins the nationwide popular vote, rather than the candidates Nevadans choose. In cases like this, where Nevada's interests could diverge from the interests of large states, I will always stand up for Nevada. End quote. This is from Governor Sisolak. AJR 6 rejects our current electoral system. It wants to skip amending the Constitution and allows only a handful of states to elect the president. Those states are the very large states, including California and New York. If the various states want to change or eliminate the Electoral College, what we need to do is to have Congress do the hard work and change the United States Constitution. However, as you may recall, Congress has refused time and time again to eliminate the Electoral College in order to protect the rights of smaller states. The National Popular Vote Compact is not only bad policy, but under the Constitution's Compact Clause is unconstitutional without the consent of Congress. We support the Electoral College formed by our nation's founders. We strenuously oppose AJR 6, and we urge all of the Assembly members here to vote against AJR 6. Thank you very much for your attention.
If you wish to testify in any position, press star 9 to take your place in the queue. Again, if you wish to testify in any position, press star 9 to take your place in the queue. Caller, press star 6 to unmute yourself, please. One moment, Chair. Caller, you're unmuted. Caller, you're unmuted. Chair, there are no more callers wishing to testify at this time.
All right, thank you, Broadcasting. Thank everyone for their patience. Appreciate all the input on this legislation. With that, we'll close the hearing on Assembly Joint Resolution number 6. And the last item on our agenda is public comment. Public comment, I'm going to limit to 2 minutes per speaker. That's regarding anything that is not regarding any of the two bills we talked about tonight. I'll start here in Carson City, then go to the phone lines. I don't see anyone at Sawyer. Good evening.
Thank you, Mr. Chairman. It's been a long hearing. My name is Janine Hansen. We just wanted to thank you for the very fair way you conducted this hearing. It isn't often that everyone that wants to speak has an opportunity at the legislature, and that your patience is, I'm sure it's tried at times. And so we greatly appreciate you being willing to hear everyone and so that all could participate. Thank you very much, Mr. Chairman.
Well, thanks for your kind comments. Thanks to all the committee members. I know the hour's late, a lot of interest in this bill. Thanks to our staff and Broadcasting. So thank you for your kind words. And we appreciate all the presenters, the folks on all sides. Don't see anyone else here with public comment. Don't see anyone at the Sawyer Building, Broadcasting. Anyone on the phone lines for public comment. We are limiting that to 2 minutes per speaker. Anything not related to AJR 6 or Assembly Bill 13.
If you would like to provide public comment, press star 9 to take your place in the queue. Chair, there are no callers wishing to provide public comment.
All right, thanks everyone. With that, we are adjourned. Thank you.